Hi, my name is Lisa Linney, and I'm an attorney with Johnsen Law in Kingwood, Texas. I'm here today to talk about employment law and how important it is for small businesses to have some very important documents in place. Those are an employee handbook, a non-solicitation agreement, and a non-disclosure agreement. And we'll talk about the state of non-competes as well. These documents are absolutely essential to protecting your business from risk of IRS audits, litigation from employees, Department of Labor investigations, and also consequences under state law. The importance and purpose of employee handbooks are these serve as the cornerstone of your policies and operations. A well-crafted employee handbook communicates your company's mission, values, and expectations. It standardizes workplace practices, and it mitigates legal risk by ensuring compliance with employment laws, as well as serving as a reference for both management and employees. It really lays out the expectation that everybody is going to operate under. It also demonstrates your commitment to your employees about treating them fairly and consistently. So, an effective employee handbook should have a welcome statement and a company overview. This is a great way to set the tone for your culture in your company, whether you are a two-person operation or an employer with thousands of employees. This lays out what you hope the workplace will be like for both management and employees. This is a great place to describe how the business got started and what the owners of the business are passionate about and the backstory of how the business was created. The employee handbook should also standardize workplace practices, and it should serve as a reference to everyone involved in the business. You should have employment policies covering equal opportunity, as well as anti-harassment and anti-discrimination, Americans with Disabilities Act, and religious accommodations procedures. Now, not all of these are applicable to small businesses. However, it is best practice to follow these even if you don't have 15 or more employees. Now, compensation and benefits information should also be included. That would be things like the pay schedule and whether direct deposit is required. It should also describe benefits eligibility and what benefits are available, such as health insurance or 401k matching or reimbursement for education. This should also describe the time off policies, whether you have unlimited PTO or you're offering the standard federal holidays and 2 weeks of vacation and X number of sick leave days. But this should also cover things like paternity leave and FMLA and things like bereavement leave or leave to go and volunteer in the community. Your handbook should also focus on workplace conduct expectations. These would be policies like attendance and punctuality, the dress code for the office or for when you're interfacing with customers. This should also include electronic communications policies, the use of the internet while on duty or at work, as well as prohibiting access to certain websites. This should also include social media policies about whether you can access social media during work and how you may characterize your employment with the company on your personal social media. You should also have safety and security protocols This could be something like the fire evacuation procedures, or any type of accident reporting. So these things should be laid out so that employees and management can use this as a reference in case of an emergency. They have a checklist to rely upon. Your handbook should include disciplinary procedures and termination policies. This lays out the procedure that employees can expect when they are facing discipline, whether that's the consequences may be a write-up or a probationary period, and what would be an offense that could end up leading to termination of the employee's relationship with the company. The handbook should also include an acknowledgement form that the employee should sign and should be kept in their personnel file. Whether you have an HR department or not, you should have and maintain personnel files on each employee. When you're creating or updating your employment handbook, you should include disclaimers that the handbook is not a contract, especially here in Texas, where we have an at-will employment system where either the employee or the company can choose to terminate the relationship for any reason. You should also reserve the right to modify the policies and procedures, and you need to ensure that the policies are compliant with federal, state, and local laws. And that's a big segment where Johnsen Law can help you out. You should review and update regularly as the laws change. We recommend an annual review of your employee handbook, and you should consistently apply the policies in order to protect your company from accusations of discrimination. Now, moving on to non-compete agreements, they are in a legal purgatory state right now. The U.S. Department of Labor issued a rule last year basically forbidding non-compete agreements in favor of the employee's right to work. However, that has been put on hold, and it's pending litigation in federal courts right now. So in Texas, a non-disclosure agreement is still effective, but they are very difficult to enforce. And courts look at geographic considerations, time considerations, and other things like the industry or market that the employee is in, and how much that may restrict their ability to make a living. So we don't recommend using non-compete agreements to rest your risk aversion or your protection of your company on. There are other more effective and more easily enforceable tools. So those include things like non-solicitation agreements. And non-solicitation agreements can apply when an employee is still with the company or whenever they leave. We can craft contracts that prohibit the employee from soliciting current employees for their own business and preventing them from soliciting your customers. These are much easier to enforce in the courts, and they also protect your vendor relationships. These also, like I said, these can apply to current or former employees. So the key elements of a non-solicitation agreement is to clearly define what a solicitation is and what behavior is prohibited. It should also specify the protected relationships, the clients, the customers, your vendors, your employees, and establish reasonable time limits, because that is something that Texas and federal courts will look at. Generally we have found that 2 years is fairly reasonable, 10 years is not. And you should also include consideration, which is one of the requirements in order to form a contract. That means that in order for you to gain this protection, your employee should also be receiving a benefit. That can be in the form of extra cash or some other form of remuneration. Now, these are less likely to face statutory impediments and impediments, and the courts are also more likely to enforce them. It is easier to justify protecting legitimate business interest rather than prohibiting a person from seeking employment elsewhere. So another important document that you should have in order to protect your business is a non-disclosure agreement. Now, this often will focus on trade secrets like customer lists and development of new products or other intellectual property. So they come in two forms. You can have a unilateral non-disclosure agreement, which is the most common in the employment context, and the employee agrees not to disclose certain information. Now, there's also a mutual non-disclosure agreement in which both parties will agree not to disclose each other's information. This would be something that often happens with a settlement agreement that's reached with an employee who has sued the company. Non-disclosure agreements, or NDAs, cover, like I said, trade secrets, proprietary processes and methods, customer and client information, your company's financial data, if you're not a publicly traded organization, business strategies and plans, and product development information. But there is more that the NDAs can cover, and that can be addressed with your particular business situation. So your NDA should include a definition of what is confidential information and outline the permitted uses of that information. It should specify exclusions like publicly available knowledge or prior knowledge prior to employment. It should include a time period for those confidentiality obligations, and also describe the return of any confidential information or property whenever the employment relationship is terminated for whatever reason. As far as enforcement of NDAs goes, you can be reasonable in the scope and duration, and a court is very likely to enforce them. This comes down to a breach of contract claim, and you could consider a liquidated damages clause, which would define how much money the company would be paid for the employee's violation of the NDA. The NDAs cannot cover illegal activity, they cannot be overbroad, and they can't attempt to prevent employees from reporting a violation to a governmental entity. So they cannot prohibit whistleblowing activities. So you should consider which agreements are appropriate and Johnsen Law, and including myself, can help you determine that depending on your particular needs of your business. You should ensure that the documents are consistent and that any agreement that is outside of the employee handbook is properly referenced. Training of managers is very important on the proper administration of the policies and procedures under the employee handbook and the agreements that we discussed. And you should also develop procedures for departing employees. Things like an exit interview or return of business property, and how they are going to transition clients and their workload, things of that nature. It can make the departure process a lot smoother for you and decrease the amount of chaos that can be created in those situations. So we recommend that you audit these documents at least annually. We recommend that you do that with your attorney. The documents will need to be updated as the laws change, and they can be customized for different jurisdictions. We have relationships. We actually have attorneys in several different states, and we have relationships with attorneys in other states. So if your business is in more than one state, then we can still be of assistance and help you to implement these documents. Again, it's very important for the company to enforce these consistently in order to give the court as much reason as possible to enforce them, and also to avoid allegations of discriminatory practices. It's very important that the company management documents any violations of these policies. This is going to help you in termination procedures if there is any question that comes up, or any governmental complaints or litigation that comes up later. This is going to be foundational to defending your company. When an employee breaches one of these contracts, one of these documents, we can send a cease and desist letter, and that typically deters a lot of future activity. However, if the behavior continues, then we encourage alternative dispute resolution, like mediation between company representatives and the employee. We also will pursue injunctive relief in court if that's necessary, where a court will order the employer or former employee to stop the behavior that is violating either the agreements or the employee handbook. You can also pursue money damages in court against the employee. And so there are a lot of remedies that the company has should an employee choose to violate the policies and procedures or the contracts. These are really powerful tools to protect your business and to set clear expectations with employees. Their effectiveness depends on proper drafting and compliance with laws. Also, they have to be reasonable in scope and on their limitations. They have to be consistently applied and enforced. And you should also do regular review and updates. Again, I recommend having these documents created or reviewed by experienced employment counsel at least annually, and I am one who can help you with that. In fact, there are several attorneys at Johnsen Law who practice in this area of employment law. So I appreciate your time today. Again, I am Lisa Linney with Johnsen Law.
I'd like to take a moment and thank you for watching. Please like, share with a friend, save for later, or subscribe to this channel to get more videos to help your business build, grow, and succeed. And of course, you can always head over to johnsenlaw.com. That's JOHNSEN law.com for more free resources.